Good morning, everyone, and welcome back to the official YouTube channel of the Islamabad Policy Research Institute. My name is Ikra Banu Suhail, and I am a research associate with the Chair International Law here at IPRI. In today's podcast, we will be tackling a very important question, I believe, and that is whether mandatory mediation can truly bridge the gap between courtrooms and communities. We will be looking at the experience of Italy and what lessons it holds for a developing legal framework in Pakistan. And to talk on that, we have the absolute honor of Ms. Chiara Tondini joining us today, who is a member of the International Law Association Italian branch. She has worked as an international arbitration and mediation counsel for SLCG, and previously she was the founder and manager of the Florence International Mediation Chamber and the Florence International Dispute Resolution Academy, with over 11 years of experience in organizing and supporting domestic and international mediation procedures. Ms. Tondini, a very good morning to you, and we are so grateful to have you on board.
Thank you for having me. It's my pleasure to be here.
No, the honor is all ours. So, to start off, could you please help our listeners understand the concept itself? What exactly does mandatory mediation mean? What are the key benefits that it offers, not just for the justice system, but also for the individuals that are involved in the disputes?
Sure, of course. Well, in principle, mandatory mediation means that engaging in mediation is a legal precondition to initiating or continuing a litigation. Okay. And typically, this requirement may be established by statute or imposed by a court order. And it takes several forms. It may apply to specific subject matters, as in Italy, where it covers a broad range of civil and commercial disputes. So it means that once you have a dispute in that subject matter, you have to attempt mediation before filing a court proceeding or arbitration. Some jurisdictions require an initial filter or so-called preliminary mediation meeting, which basically is a meeting when the mediator explains the parties the purpose and the functioning of the process, and then the parties have to express their consent to go ahead with the actual mediation. And some other jurisdictions empower judges to refer parties to mediation pending the court proceeding, so the so-called court-ordered mediation, and impose specific consequences for non-compliance. Okay. In Italy, once the judge orders mediation, if the parties does not effectively attempt to mediate, of course, they are not obliged to settle, but they must attempt to mediate in good faith. If they don't, the case is dismissed. Okay. And with regard to the benefits, I actually have my personal ranking. Because what I value the most is how mandatory mediation promotes a settlement culture. I mean, in litigation-heavy civil law system like Italy is, mediation rarely becomes part of legal practice unless parties are compelled to try it. And it is necessary to bring all stakeholders to the table, meaning parties, lawyers, experts, to the mediation table, I was saying, to make them realize its potential. And if supported by quality and efficient process, and this is key, mediation often creates more value than adversarial process ever could. And among other things, by keeping the parties in control of outcomes, okay, they decide what they want to do of their dispute, of their conflict, and preserving relationship. And once this is achieved, the effect has not just legal, but also social and economic, and can have an impact both internally and internationally. And second, I rank deflection of court case loads. And this is usually listed at the top benefit. This is why I say that I have, an unusual position. But I mean, it's true. Mandatory mediation does help relieve court backlog, and in so doing, enhances the justice system and the access to it. But to create a solid and lasting mediation culture, in my opinion, this should be presented as a positive consequence and not the core purpose. Otherwise, the parties feel, I mean, sort of tool to achieve a goal which they not perceive as inherent to their immediate scopes and immediate to their immediate objectives.
Okay, yeah, that's great. Thank you for that clear explanation. In Pakistan as well, generally, many people are now seeing mediation as a promising way to ease the burden on courts and resolve conflicts more, I would say, amicably. However, there is still some resistance about how mandatory mediation is going to fit within our traditional and social practices, right? It has not been formally introduced in Pakistan as of yet. We do have an Alternative Dispute Resolution Act, but even that does not explicitly provide for the concept of mandatory mediation. However, the idea is definitely gaining momentum, especially from the judiciary itself. There has been a lot of support. The Supreme Court of Pakistan has been strongly advocating for the increased use of mediation, especially being mindful of the massive backlog of cases that are burdening the courts. Over 1.7 million pending cases. It's a huge number, I mean. So the Supreme Court has issued directives encouraging the referral of suitable disputes, I would say, to mediation, and the establishment of mediation centers as well across different jurisdiction. But drawing from your experience in Italy, Ms. Tondini, where mandatory mediation has initially faced a lot of resistance, right? How can countries like Pakistan find the right balance between voluntary and mandatory mediation to avoid similar pushback from the legal community? And what important social factors should Pakistan consider to make sure that any new mediation system is accessible, it is also trusted by the public, and it is also respectful of our existing traditional dispute resolution practices?
Sure. Well, I'm happy to hear that. I mean, Pakistani judiciary is already forward-looking and on the right way and with the right mindset to establish a solid framework in that sense. Well, drawing from Italy's experience, I would recommend a phased approach. I mean, as an example, begin with disputes naturally suited to mediation, okay, such as commercial and corporate matters that are the first that come to my mind, because in this field, efficiency, confidentiality, and relationships preservation are paramount. And then, I mean, we can say that time is money, okay? And then gradually extended to related sectors, such as banking, finance, commercialism. So to, I mean, widen step by step the community interested by mandatory mediation, and gradually make mediation accepted, mandatory mediation accepted in the Pakistani community. And what I mean is that often mandatory mediation is introduced based on litigation volumes, as you said, of course. But we need to make sure that this also correlates with cases mediability, as you said. Okay, so selecting areas based on the quality of outcomes rather than the quantity of court filings can be very effective. So I would recommend this attention when implementing it. And also pay attention to financial accessibility. So offer free mediation services if it is possible, but I understand that it cannot be always be possible or not for all cases. And then study mechanisms to reduce fees for mandatory case. Okay. And then I would say complement with incentives for voluntary mediations. Okay, so financial incentives. In Italy, the most common are tax credits for parties who attempt mediation with a special bonus if the case is settled. Or also study litigation cost reduction. And in this sense, it comes to my mind what the ICC does, the International Chamber of Commerce, which of course is a private mediation provider, but they offer discounts on the costs of arbitration filing fees, okay, if mediation has been previously attempted. In so doing, parties do not perceive mediation as an additional financial burden, but they feel and they perceive it as an additional opportunity. Yeah. Okay, they have nothing to lose. Okay, and importantly, of course, invest in quality. So nurture and pay very high attention to the training and the education of mediators, counsel, mediation providers, and judges. Because regardless of the outcome, and remember that settlement is not always the best option. I mean, a good mediation is not only the one where parties settle the case, but is, in my opinion, the one where the parties have gained more awareness of the case, have gained more information, so that they are more in control and they are able to understand which is the best outcome for them. This is the good mediation. And thus it is fundamental, it is crucial that mediation is a good experience and that quality of the preparation of mediators, of the administrative institution, of the lawyers assisting the parties is high. And finally, and I conclude, it is important to avoid framing mediation as a litigation rival. I mean, it is not an either-or matter. They are two complementary tools. And the ability and the skills to build the capacity to be built of judges, mediators, and mediation advocates, and is to prepare them to understand how to handle all these tools together, okay? Because it is also important to be aware that not all cases can be mediated, as I said earlier. And mediation is not the best option for all disputes, but it is important to understand when mediation is the best option in the dispute at hand. And coming to social and cultural sensitivity that you anticipated, I would say that this is key, of course, to make mediation being accepted within a community. And I would list the aspects that are more important for me. First, I would suggest to assess the cultural norms about disputes within the country, such as how hierarchy, for example, face saving, shame are perceived in the country's culture, okay? And shape the mechanism and train stakeholders accordingly. Because a country's cultural approach to disputes, such as the importance of preserving face and maintaining social harmonies rather than avoiding conflict, okay? Some cultures are more direct in this, some other avoid facing the conflict. This is important. And legislation and knowledge frameworks could be shaped to accommodate these features. As an example, by accommodating the use of a certain mediation style, so training mediators to use facilitative mediation rather than evaluative, or the role of confidentiality, or how to use private rather than joint sessions, and so on. And this would make users feel comfortable and would entrust them more with greater ease, I would say. Second, respect for existing resolution mechanisms. So I don't know whether Pakistan has traditional informal dispute resolution mechanisms, such as those held by local elders, or rather than a reconciliation, I don't know. And this because any formal mediation system needs to ensure that it doesn't displace or disrespect those existing. So whenever possible, integrate and allow coexistence. Okay, they can be complementary. Third, I would say enhance geographic, linguistic, and financial accessibility, as I said.
Yes.
Because if mediation is mandatory, but or it is even perceived as inaccessible, that breeds injustice, you know. And fourth, and I conclude, I would say government support and institutional framework. So ensure it, because it is important to cure establishment of quality mediation centers, but I understand that Pakistan already have, and ensuring transparent and effective accreditation mechanisms, because it is important that mediators are prepared, but also that parties are enabled to verify their training process, so build accreditation and certification path, and so on. So credibility is important. Reliability is also important.
Yes.
And also provide for funding mechanisms where it is possible, so to support, in particular, low-income parties and so on. So all of these measures, I believe that are complementary and helpful with each other.
Yeah, yeah. No, that's wonderful, and I definitely agree. This has been a part of our culture for generations, as you mentioned it as well. So I think this blending of tradition and modernity might just be the key to overcoming resistance and achieving the success that we're looking for. So I think it's just a matter of how we formalize it and how are we going to build that trust, right? Because it's going to be a blend, it's going to be something that coexists. So moving forward, the Reforma Cartabia in Italy, right? That emphasizes on the concept of mandatory judicial training as a key element in fostering a sustainable mediation culture in Italy. So, from your perspective, Ms. Tondini, how crucial is ongoing judicial engagement and training for the success of mediation systems? And what complementary roles should the bar councils play in the process as well? Specifically, what responsibilities or training programs can bar councils implement to encourage lawyers to uphold mediation clauses in contracts?
Sure. Well, first of all, raising awareness within the judiciary is essential. And judges who understand mediation are more inclined to endorse it actively. But as I said, I understand that in Pakistan, we are already on the right path to this, because you have a very active Supreme Court. And this also motivates parties to engage, and also enables the judiciary to use procedural tools to ensure that the process is substantive, because the main procedural danger when you embark in introducing mandatory mediation in your legislative framework is that it may become a so-called tick the box, you know. I mean, parties just formally attempt the process just to be unable to start or to continue the court proceedings. So this is fundamental. And then with regard to the bar councils, I would say that their role is equally pivotal. So it is important that bar councils invest in education, and also they are very pragmatic, let's be honest. So highlighting the benefits for lawyers of mediation for their profession, and this from diverse angles, because it is necessary to show lawyers that mediation can reduce the time and cost of litigation, but not at the detriment of their income. So, but on the contrary, it can free up their capacity for other work. And it can raise their reputation and appreciation by clients, because they are more rewarded by faster and cheaper outcomes. And in that sense, there are statistics and calculations that I would be happy to share, I mean, if you're interested in, that show that mediation is financially profitable for lawyers, because apparently fees may be lower than litigation, but the
Okay.
process is faster, so they are able to embark more work, they are able to embark more engagements, and clients are less afraid to refer to lawyers because they know that they can have cheaper solutions rather than time-consuming and expensive courts trial, of course. And this, I would say, that also debarks the long-cited common law systems BUTAD that ADR instead for alternative disputes resolution stands for alarming drop in revenues. Okay, and
Yeah.
I would also say that it is not possible to achieve results without synergy among all stakeholders. Okay, synergy is key. I would
Yeah.
say that it is unavoidable. And
Yeah.
to this point, I want just to mention a project implemented by the Florence Law School
Okay.
and supported by the Bar Council and the local mediation providers. And the project consisted in the law school providing interns and young scholars to assist judges in the Florence court by studying the court files and assessing which cases were suitable to be settled in mediation, because the Florence court had staff shortages. Okay, so they couldn't help in examining all the files to assess which of them were suitable to be mediated, and thus the law school supported it. And when a case was considered suitable, the judge ordered mediation. Then mediation administered institution who applied the discounted fees to the party ordered mediation, so supported the project in that way, shared with the law school anonymized data of the cases for research purposes. Okay, so a study was made in it. And in 2018, which was the inaugural year of the project, 47.9% of the cases sent to mediation resulted in a settlement. And
Interesting.
yes, and I believe that this data is even more significant considering not only the compulsory nature of the proceedings, but also that in many cases mediation happened when parties had been in litigation since years, and thus they had a high level of conflict escalation. And I have also heard of another similar project implemented by the Georgian court when the rate of settlement reached between 60 and 70%. So I believe that also implementing this project to show data, okay, to show numbers, helps to fast and trust both professionals, meaning lawyers, and the parties, because they provide credibility. And additionally, what Bar Council can do in practice, I would say first, of course, educate lawyers. So explain what mediation is and show them that it's a professional tool and not a threat to their practice. And I see that although Bar Council, the Italian Bar Council has not a specific obligation to do it, but in practice, it offers many courses to lawyers in their continuous training duty, the CPD obligation. It offers many courses on mediation, so they are doing great things in that sense. And I would say, with regard to your concern to contract clauses, I would say promote and encourage the use of model clauses. So Bar Council could draft tested model clauses which stand possible interpretation issues and so on, but also strongly recommend the use of model clauses drafted by administered institutions, because these are, I mean, almost all administered institutions propose model clauses. They are simply published on their website. And these are really battle-tested clauses and designed to avoid procedural process. So this is very important. Then I would say implement a fee mechanisms that incentivize lawyers to propose mediation to their clients. Okay, I don't know how it works in Pakistan to this extent, but in Italy, lawyers' fees are approved by the Bar Council. So if Bar Council empower lawyers to, charge fees that are profitable also in when they assist parties in mediation, they will be more incentivized to use it. Okay. And finally, of course, ensure support from legislator and judiciary, because aligning the regulation of mediation so to ensure effectiveness of mediation clauses will strengthen motivation. If you have a solid basis, of course, you will be more incentivized to use it.
Yeah, that's a great point. And we will be more than happy to have a look at the cost breakdown that you just mentioned. We would be more than happy to take a look at that as well. From what I could conclude from your discussion is that mediation at the end of the day relies on like one ultimate combo, I would say, that is the courts, practitioners, and the bar council that are all working together in harmony, right?
Yes, definitely.
Yeah. We all know that in today's world, commercial disputes, if we could talk a little bit about that as well, they are now crossing borders. And that makes effective resolution even more important for us. International investors and businesses are insisting on mediation clauses in contracts as a safeguard. The United Nations Convention on International Settlement Agreements, which agreements from mediation, which we know as the Singapore Convention, it further strengthens this confidence. Because it provides an internationally recognized legal framework to enforce mediated settlement agreements across jurisdictions, right? And Pakistan has recently, I believe in March, signed the Singapore Convention. So how do you see these developments shaping Pakistan's mediation landscape as it has now signed the convention as well? And additionally, how should Pakistan approach the debate on the breadth of the future court judgments under the convention to balance supporting cross-border mediation while respecting domestic legal principles?
Sure. Well, of course, the signature of the Singapore Convention by Pakistan represents per se a unique opportunity to modernize its dispute resolution framework and align it with international standards. So this is an advantage, okay, regardless of what will happen in the future. And I assume now that legislative preparation are currently underway for the convention ratification. I don't know, but I assume that it is that way. And with regard to the benefits of for mediation culture, the convention itself, it's a milestone. It gives the parties confidence that cross-border mediated settlement agreement will be enforceable, and that's the game changer, because this benefits to both the use of mediation and to Pakistan's growth in international trade and investment. Yeah. Okay, it aligns the Pakistan mediation legislation framework to those of all the other parties who have signed and ratified the convention, and thus it increases the countries being part of a community, I would say. And here's what I would suggest Pakistan to consider. I would say first, draft clear, harmonized, implementing legislation, of course, that defines when, it clearly defines when and how settlement agreements will be enforced, and what qualifies as mediation under domestic law, because this is the key, of course. This is the point of connection. And to this extent, as an example, adopting the UNCITRAL model law as a template would be of particular advantage. Even though I gave a look to the ADR Act of 2017, okay. I understand, yes. And I have seen that it already provides a strong foundation and clear definition of mediation, and which is consistent with both the model law and the convention. And second, I would say clearly define the competent authority to handle enforcement requests, so to avoid jurisdictional issues and so on. And also to support specialization. I I mean, I would say, to the extent possible, concentrate the power to judge on these cases to one single authority. And this because, as you know, usually international settlement agreements, whether international or internal, are spontaneously executed. Thus, we can optimistically expect that cases where enforcement of international settlement agreement will be requested will be rare, okay? Just seldom it will happen. Mm. And thus, it is difficult to have specialized judiciary bodies if they do not have the opportunities to gain experience. This is why I would suggest to concentrate this competence within a single body. And then to your concern that Pakistani legal principles are preserved, I would say that it is important to ensure that grounds for refusal are aligned with Article 5 of the Convention, okay, which regulates grounds for refusal. But also Article 5 contains a solid safeguards of the state party legal principles, because it expressly provides the state's right to refuse enforcement of the settlement agreement when granting it is contrary to its public policy. Okay, so...
Okay.
I mean, this is of great reassurance. And last point, I would say engage the judiciary early on. So to providing them with guidance and ongoing training on interpreting the convention and applying international settlement agreements. So maybe when ratification is still underway, involve them in the process early on. To enable them to handle public policy exception with confidence when they will materialize, if they will materialize, and ensure the convention's effective implementation.
Yeah.
So these are my 2 pence, I would say.
No, that's wonderful. I must say that all the recommendations that you have given so far, they are very concrete and actionable. So I'm really glad that we decided to have this podcast, because the recommendations, there's something that is very doable as well. So that's, I'm really glad. Yeah, thank you so much. And so drawing from all these successes, the challenges, the recommendations that you have given, in order to wrap up this conversation, I would like to ask you one last thing. So after all of this conversation, what do you think, in your opinion, what is the most important piece of advice that you would like to offer to Pakistani policymakers as they are currently in the process of building a strong and hopefully a lasting mediation culture?
Okay, well, if I had to pick one, I would say do not underestimate the potential of synergy in your implementation strategy. And this is because Italy overcame the fierce resistance that you know by the legal community, by lawyers, to mediation through genuine and joint engagement of all stakeholders. So, of course, lawyers, but also policymakers, judges, mediators, providers, and parties. And ensure that each actor feels valued, involved, incentivized, and rewarded. So, I mean, show respect for their role, for their knowledge, for their part in the process, so that each of them can validly contribute. And please be mindful that it is a tailor-made process, as you said, because, of course, you have to look at the Pakistani specific features in terms of culture, in terms of where the legal framework stands, and so on. And be mindful that change won't happen overnight. Actually, it's more than one piece of advice, but I believe it's important that resistance is naturally, especially in systems where litigation has long been the dominant model. And early results may be slow, but that doesn't mean that effort is failing. And on the contrary, it means that you are laying solid foundation, I would say. And so just to conclude, I would say invest in relationships and give the systems time to mature. And if you maintain that synergy, culture of mediation will grow.
Fantastic. And I'm really hopeful that the ideas that you have reflected on will be a part of Pakistan's landscape moving forward. I believe that this brings us to the end of our podcast. Thank you so much for such a
Thank
wonderful
you.
discourse and sharing the Italian experience in such detail. Pakistan definitely has things that it can learn from Italy, ranging from the initial resistance that it faced to the formalization of this wonderful concept. I'm really grateful. We had a wonderful discourse. And I would also like to thank the audience. Please subscribe to our channel to watch more of our podcasts. Thank you.